Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living in Utah. Today we're continuing our series about managing other people's money. Now, we get that from this library of books published by the Consumer Financial Protection Bureau about the duties of people managing money for others. And in previous videos, we have covered some of the logistics that come with different types of roles or capacities of managing other people's money, such as a guardian, conservator, or as a trustee, or as an agent under a power of attorney. Today we are kicking off some videos about managing other people's money by type of asset. So if you are, for whatever reason, in charge of managing finances for someone else, we're going to talk about how different assets vary in the state of Utah. Today specifically, real estate. With real estate, it's really if the real estate is going to stay where it is as far as title is, so if it's in a trust, if you're leaving it in a trust, or if it's in this person's name and it's staying in that person's name, it's a little bit easier. The change of title is where it gets really tricky for you as a fiduciary or as someone who's managing money for someone else. However, as long as the title isn't changing, there really isn't a whole lot that you've got to look out for other than that. So we'll come back to that later. But let's say, for example, you are an agent on a power of attorney and somebody is incapacitated. Maybe it's a parent or a sibling or a family friend, and they can no longer manage that property for themselves. As their agent, you do have the authority to manage that real estate for them. You can have renters in there and collect income. You can make improvements to the property and keep it up. You want to take care of that property as if it was being managed by the person you're representing. This is the same for trustees of a trust or guardians or conservators of the property of someone else. Your job is to take care of that property as the person whose property it is would have taken care of it. There are some ethical issues, or rather legal issues, you can run into with management of real estate. If you have multiple residential units, you can at a certain point become it can be required of you to either work through a licensed real estate company or obtain that licensure yourself. So be aware of that and talk to your local attorney if you have any questions about that. If you are one of the major ethical issues we'll run into is that one of the children will be managing the money for mom and dad. Mom and dad go into a facility, the child moves into the house and is living there rent-free and charging mom and dad for all the utilities and everything like that. If you were living there previously and you were the primary caretaker, and that is an understood arrangement, preferably in writing, that might be okay. However, if not, you need to take extra steps to make sure that you are well aware of your responsibilities to the people you are whose assets you're managing, especially when it comes to the real estate. Finally, when change of title is a common concern with people who are managing money for someone else. For example, mom and dad get a stroke or Alzheimer's or something like that, and they can no longer sign, but they're still living. If you are their successor trustee under a trust, this shouldn't be an issue at all. A title company is going to sign right off on that as long as you have the trust documents and you can show whatever the terms of the trust are for showing incapacity of the original trustees. As long as you can show that, you're good. It becomes a little more tricky when you are an agent on a power of attorney. Most title companies in Utah will not allow a real estate conveyance through a power of attorney unless it fulfills two criteria. Number one, it has to be within a year of the signing of the power of attorney, and two, the power of attorney has to specifically list that piece of property as something that's covered by the powers granted in the power of attorney. Now, by law, that's a little different. By law, the power of attorney is effective as to any piece of real estate. However, a title company is not going to insure that property unless it fits those two criteria, meaning a bank is never going to lend on that property unless it fits those two criteria. So if it does not fit those two criteria, your options are to either go to court and get a conservatorship, or wait to sell the property until they've passed away, or if you can find a cash buyer who understands the title risks of that power of attorney, and you've obtained legal counsel and it is a valid power of attorney and there's going to be no dispute there, then you might be okay conveying it that way. So in conclusion, with real estate, the major things you're going to want to look out for are, number one, ethical issues. So are you benefiting from the use of the real estate at all as this fiduciary, as this person who's managing the money for someone else? Number two, any kind of legal issues. Are you going to run into problems with managing real estate? Have you stepped into the shoes of a real estate management company or not at this point? And if you've got multiple properties, that is something you want to look into. And number three, if you need to convey title, if you need to sell this property in any way, are you going to be able to do it in an efficient way, or are the documents going to be insufficient and will have to be supplemented with other means, whether through the court or through affidavits? So thanks for watching. If you have any questions about managing real estate for others, feel free to reach out to us anytime.